Welcome back, family. Before we begin today's story, comment where you're watching from. Today's story is about how a simple gold cross necklace would expose the fine line between authority and constitutional rights in one of Los Angeles's busiest courthouses. On a bright Monday morning, the marble halls of the Stanley Moss Courthouse echoed with the usual bustle of justice in motion. Among the crowd of suited lawyers and anxious defendants, an elderly gentleman made his way through the security checkpoint. Charles Bronson, 82 years old, wore a well-worn but immaculately pressed navy suit, his silver hair neatly combed, and around his neck, a small gold cross that had been his late wife's final gift to him. The cross had never been an issue in the 40 years he had practiced law in these very halls, or during his 3 decades teaching constitutional law at UCLA. But today would be different. Today, he would encounter Judge Elizabeth Morrison, newly appointed and eager to establish her authority through strict adherence to courthouse rules. Officer David Sullivan, manning the security checkpoint, was the first to notice the cross. He had been briefed about Judge Morrison's recent directive regarding religious symbols in her courtroom. "Sir," he called out to Bronson, "you'll need to remove the necklace before entering courtroom 4B. Bronson's response was gentle but firm. "Young man, I've worn this cross in every federal and state courthouse from here to Washington, D.C. for the past 40 years. It's neither a disruption nor a security risk." The exchange caught the attention of Rachel Anderson, a young public defender waiting to enter the same courtroom. She recognized Bronson from her law school textbooks but remained quiet, watching the scene unfold with growing interest. Inside courtroom 4B, Judge Morrison sat behind her imposing bench, reviewing the day's docket. At 42, she was one of the youngest judges in the district, and her reputation for strict courtroom decorum was already well known. When Bronson entered, still wearing his cross, her eyes narrowed almost imperceptibly. "Mr. Bronson," she called out, her voice carrying the weight of newly minted authority, "religious symbols are not permitted in my courtroom. You'll need to remove the cross or face a contempt citation." The courtroom fell silent. Michael Cooper, the court clerk, looked up from his computer, his fingers frozen mid-type. Lisa Martinez, a legal intern, quickly began taking notes, sensing that something significant was about to unfold. Bronson stood slowly, his movements deliberate and dignified. "Your Honor," he began, his voice carrying decades of courtroom experience, "I mean no disrespect, but I must decline." Judge Morrison's face flushed slightly. "Mr. Bronson, this is not a debate. Remove the cross or face a fine for contempt of court." "With all due respect, Your Honor," Bronson continued calmly, "I believe we're about to engage in a rather interesting constitutional discussion." The judge's gavel came down sharply. "That will be a $1,000 fine for contempt, Mr. Bronson. Would you like to rethink your position?" A subtle smile crossed Bronson's weathered face. "Actually, Your Honor, I would like to cite Cohen v. California, 1971, where the Supreme Court established that the state cannot criminalize the peaceful expression of messages, including symbolic speech. Furthermore, Richard Brooks, the senior bailiff who had seen his share of courtroom drama over 3 decades, noticed something unusual. The usual tension of a contempt citation was missing. Instead, there was an almost electric atmosphere of anticipation as the elderly man began to speak. "Your Honor," Bronson continued, his voice taking on the familiar cadence of a seasoned professor, "we might also consider Capitol Square Review Board v. Panett, where the Supreme Court held that religious expression cannot be singled out for discriminatory treatment." Judge Morrison's expression began to shift as Bronson continued citing precedent after precedent, each one delivered with perfect recall and precise relevance. Rachel Anderson had pulled out her phone, discreetly recording every citation for later reference. Andrew Phillips, the courthouse reporter who had initially dozed off during what he thought would be another routine morning, was now furiously taking notes. This wasn't just a story about a defiant old man. This was about constitutional law being debated in real time. Furthermore, Bronson added, his voice growing stronger, under the Religious Freedom Restoration Act, any government action that substantially burdens the exercise of religion must be the least restrictive means of furthering a compelling government interest. I would be very interested, Your Honor, in hearing the compelling government interest in requiring me to remove a small cross that has never disrupted any proceeding in 4 decades of legal practice. The courtroom had grown so quiet you could hear the gentle whir of the air conditioning. Judge Morrison, who had started the exchange with the confidence of absolute authority, now found herself in the unusual position of being on the defensive. Lisa Martinez, the legal intern, had abandoned all pretense of discretion and was openly recording every word. As a first-year law student, she was witnessing what would normally take weeks to cover in her constitutional law class. "Your Honor," Bronson continued, his tone respectful but unwavering, "we might also consider the precedent set in Good News Club versus Milford Central School, where the Supreme Court held that discrimination against religious viewpoints constitutes unconstitutional viewpoint discrimination under the First Amendment." Judge Morrison's legal training warred with her desire to maintain control of her courtroom. She was beginning to realize that this elderly man wasn't just any attorney, he was Charles Bronson, the same constitutional law expert whose textbooks she had studied in law school. Michael Cooper, the court clerk, had stopped even pretending to work. Like everyone else in the courtroom, he was watching a masterclass in constitutional law unfold. The $1,000 fine, still hanging in the air, now seemed like a small price for the education everyone was receiving. Bronson wasn't done. With the patience of a seasoned educator, he began explaining how the courthouse's selective enforcement of religious symbol restrictions might actually violate the Establishment Clause by showing preference for secular over religious expression. "And finally, Your Honor," he concluded, "I would direct your attention to the Religious Land Use and Institutionalized Persons Act, which requires strict scrutiny of any government action that substantially burdens religious exercise. While this act primarily applies to land use and prisoners' rights, its underlying principle, that religious expression deserves the highest level of constitutional protection, is directly relevant to our current situation." The courtroom remained silent as Judge Morrison contemplated her next move. She had 3 options: enforce her rule and face a constitutional challenge that would likely succeed, back down and lose face, or find a way to gracefully acknowledge the constitutional principles at stake. Andrew Phillips had already started composing his headline, "Constitutional Expert Turns Courtroom into Law School Classroom." This wasn't just about a cross anymore. It was about the delicate balance between authority and rights, between rules and wisdom. And there you have it, family. Sometimes the most powerful lessons come not from force, but from knowledge, not from authority, but from understanding. Has anyone ever tried to silence your voice, only to discover you knew exactly how to defend your rights? Share your story in the comments below. The tension in courtroom 4B had reached a pivotal moment. Judge Elizabeth Morrison sat behind her bench, facing an unexpected challenge to her authority from a man who had quite literally written the book on constitutional law. The simple gold cross around Charles Bronson's neck had become the centerpiece of a constitutional law seminar that nobody in the courthouse had expected to attend that morning. Rachel Anderson, the young public defender, had discreetly begun researching Bronson's background on her tablet. What she discovered made her eyes widen. Charles Bronson wasn't just any constitutional law professor. He had argued 7 cases before the Supreme Court, winning 6 of them. His textbook, Constitutional Rights in Modern America, was required reading at most law schools, including the one Judge Morrison had attended. Judge Morrison cleared her throat, attempting to regain control of her courtroom. "Mr. Bronson, while your legal expertise is noted, this courtroom operates under specific rules designed to maintain order and decorum." Bronson's response was gentle but precise. "Indeed, Your Honor. And as you'll recall from your own legal studies, perhaps even from my textbook's chapter on judicial discretion, those rules must still operate within constitutional boundaries." The mention of his textbook caused a subtle shift in the judge's expression. Lisa Martinez, the legal intern, noticed how Judge Morrison's hand moved instinctively toward her desk drawer, where a well-worn copy of Bronson's book sat among her reference materials. "Your Honor," Bronson continued, his voice carrying the weight of decades of legal experience, "perhaps we might consider this an opportunity for a broader discussion about the intersection of religious freedom and courtroom procedure. After all, isn't that why we're all here? To ensure justice is served while protecting constitutional rights." Michael Cooper, the court clerk, was quietly pulling up relevant cases on his computer. Each precedent Bronson had cited was appearing on his screen, perfectly relevant, perfectly applicable. This wasn't just an elderly man resisting authority, this was a master of constitutional law conducting a clinic. Officer David Sullivan, who had initially confronted Bronson at the security checkpoint, found himself drawn into the impromptu lesson. In his 15 years of courthouse security, he had never witnessed anything quite like this, a challenge to authority that came not through defiance, but through deep understanding of the law. Judge Morrison attempted another approach. Mr. Bronson, surely you understand the need for consistent application of courtroom rules. If we make an exception for your cross, where do we draw the line? Bronson's eyes twinkled as he responded, the slippery slope argument. Your Honor, as you'll find in Trinity Lutheran Church versus Comer, the Supreme Court explicitly rejected the notion that religious expression can be categorically excluded from public benefits or spaces merely for being religious. The question isn't where we draw the line, it's whether the line itself is constitutional. Richard Brooks, the senior bailiff, noticed something remarkable happening in the gallery. Lawyers who had been waiting for their cases to be called were taking notes. Law students present for other proceedings had abandoned their original cases to watch this unexpected confrontation unfold. Andrew Phillips, the courthouse reporter, was already imagining the story's angle. In an age of quick judgments and rigid rules, an 82-year-old constitutional expert reminds us why legal principles matter. The tension escalated when Judge Morrison tried a different tactic. Mr. Bronson, your impressive legal career notwithstanding, this is my courtroom. The fine stands at $1,000. Would you like to make it $2,000? Bronson's response was a masterclass in respectful disagreement. Your Honor, with great respect, I would direct your attention to the case of West Virginia State Board of Education versus Barnett. The Supreme Court held that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion. The principle applies even in, perhaps especially in, your courtroom. Rachel Anderson had been quietly compiling a list of the cited cases. She realized that Bronson wasn't just defending his right to wear a cross. He was providing a comprehensive lesson in constitutional law that would benefit everyone present. Lisa Martinez's notebook was filling up rapidly. As a first-year law student, she was witnessing what amounted to a semester's worth of constitutional law being demonstrated in real time. The way Bronson wove together various precedents and principles was nothing short of masterful. Judge Morrison found herself in an increasingly difficult position. Every attempt to assert her authority was met with precise, relevant legal precedent. The simple act of demanding a cross be removed had evolved into a constitutional law debate that she hadn't anticipated and wasn't prepared for. Your Honor, Bronson continued, his tone remaining respectful, perhaps we might consider Justice Robert Jackson's famous words from West Virginia versus Barnett. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in matters of conscience. The gallery had grown larger as word spread through the courthouse. Lawyers from other courtrooms were finding excuses to step in, drawn by the opportunity to witness this unexpected lesson in constitutional law. Michael Cooper noticed that several judges from other courtrooms had discreetly entered through the back door, standing quietly to observe the proceedings. The implications of this case would likely affect their own courtroom policies. Officer David Sullivan, still stationed by the door, overheard snippets of conversation as more people entered. That's Charles Bronson. Wrote the textbook, 7 Supreme Court cases. This is better than law school. Judge Morrison was facing a crucial decision. Every minute this confrontation continued, more people were gathering to witness it. Her authority wasn't just being challenged, it was being used as a teaching moment for everyone present. Bronson seemed to sense her dilemma. Your Honor, might I suggest that the true strength of our legal system lies not in rigid adherence to rules, but in our ability to apply them with wisdom and constitutional awareness? After all, as Justice Brennan noted in Goldman versus Weinberger, the Constitution doesn't abandon its protection at the courthouse door. Rachel Anderson had begun sharing her notes with other lawyers in the gallery. The impromptu constitutional law lesson was becoming a collaborative learning experience, with attorneys and law students alike comparing notes and discussing the implications of each cited case. Lisa Martinez's hand was cramping from taking notes, but she didn't dare stop. This was the kind of real-world legal education that no classroom could provide, watching a constitutional expert systematically dismantle an unconstitutional rule while maintaining absolute respect for the court. The atmosphere in the courtroom had transformed. What had started as a confrontation over a simple cross had become a seminar on constitutional rights, judicial discretion, and the limits of authority. The $1,000 fine still hung in the air, but it had become almost secondary to the larger principles being discussed. Andrew Phillips had abandoned his usual cynical reporter's stance. This wasn't just another courthouse story. This was about fundamental principles of law and justice being defended by someone who had spent a lifetime understanding and teaching them. Bronson's voice carried clearly as he continued, "Your Honor, consider if you will the practical implications of your rule. Would you require a Muslim woman to remove her hijab? A Sikh man his turban? The constitutional principles at stake here extend far beyond my simple cross." The examples hit home. Judge Morrison had not considered these implications when establishing her rule about religious symbols. The constitutional dimensions of her blanket prohibition were becoming increasingly problematic. Richard Brooks, watching from his position near the bench, could see the subtle changes in Judge Morrison's expression. The certainty with which she had issued the fine was wavering in the face of Bronson's methodical constitutional analysis. The courtroom had become so quiet that when Lisa Martinez's pen ran out of ink, the click of her replacing it was clearly audible. Nobody wanted to miss a word of this unexpected lesson in constitutional law and judicial wisdom. Michael Cooper noticed that his computer screen was filling up with messages from other court clerks throughout the building, all asking for updates on what was happening in courtroom 4B. Word had spread that something extraordinary was taking place. A collision between authority and expertise that was transforming into a teaching moment for everyone present. As the morning wore on, it became clear that this was more than a simple dispute over a religious symbol. It was a reminder of why constitutional principles matter, why legal expertise should be respected, and why sometimes the most powerful lessons come from unexpected challenges to authority. And through it all, the small gold cross continued to catch the light. A simple symbol that had sparked an extraordinary demonstration of legal knowledge and constitutional principles. As the morning session continued in courtroom 4B, what had begun as a simple contempt citation had evolved into something far more significant. The growing crowd of spectators included not just lawyers and law students, but also several judges who had taken brief recesses from their own courtrooms to witness this extraordinary display of constitutional expertise. Judge Elizabeth Morrison found herself in an increasingly precarious position. Each attempt to assert her authority was met with impeccable legal reasoning from Charles Bronson, whose gentle but firm responses were transforming her courtroom into an unprecedented teaching moment. Rachel Anderson, still documenting every citation and argument, noticed something remarkable. Her fellow attorneys, normally competitive and hurried, were sharing notes and discussing the implications of each point Bronson raised. The adversarial atmosphere typical of a courtroom had transformed into something more akin to a collaborative legal symposium. "Your Honor," Bronson continued, his voice carrying the weight of decades of legal wisdom, "perhaps we might examine the historical context of religious expression in public spaces. The Supreme Court's decision in Lynch v. Donnelly reminds us that total separation of church and state is not what the founders intended." Lisa Martinez, the legal intern, had abandoned her regular notepad for her laptop, typing furiously to capture every word. She realized she was witnessing something that would likely be discussed in law schools for years to come, a masterclass in constitutional law delivered in real time. The turning point came when Michael Cooper, the court clerk, respectfully approached the bench with a printout. "Your Honor," he said quietly, "I've found something relevant in the court's own policies." The document he handed her was a directive from the chief judge of the district, dated just 3 months earlier, specifically addressing religious accommodation in courtrooms. Judge Morrison's expression shifted as she read the document. The directive explicitly stated that religious symbols worn as personal items of faith were to be permitted unless they posed a specific security risk or disrupted court proceedings. Her blanket prohibition, it seemed, wasn't just constitutionally questionable, it was contrary to court policy. Bronson, seeing the exchange, demonstrated the grace that had marked his entire legal career. Your Honor, might I suggest that this presents an excellent opportunity for us all to reflect on how constitutional principles inform and shape our institutional policies? The gathered crowd held its breath. Judge Morrison had a choice to make, one that would define not just this moment, but potentially her entire judicial career. She could either dig in her heels, forcing a constitutional confrontation that would likely lead to appeals and embarrassing headlines, or she could demonstrate the kind of judicial wisdom that Bronson had been quietly advocating for. Andrew Phillips, the courthouse reporter, had already drafted 2 different headlines in his notebook: "Judge stands ground against constitutional expert," and "Judicial wisdom prevails in constitutional showdown." He was hoping he'd get to use the second one. Richard Brooks, the senior bailiff, noticed a subtle change in the courtroom's atmosphere. The tension of confrontation had transformed into the anticipation of resolution. In his 30 years of service, he had never seen a potential conflict dissolve so elegantly into a learning opportunity. Officer David Sullivan, still at his post by the door, reflected on how this morning had changed his own understanding of his role. The next time he encountered someone wearing a religious symbol, he would remember this lesson in constitutional rights and institutional responsibility. Judge Morrison cleared her throat, the sound carrying clearly in the silent courtroom. "Mr. Bronson," she began, her voice steady, "your arguments have been illuminating. It appears I need to revise my position on this matter." A murmur of approval rippled through the gallery. Lisa Martinez's fingers flew across her keyboard, capturing what she already knew would be a defining moment in her legal education. But Bronson wasn't finished. With the same gentle authority that had characterized his entire presentation, he offered Judge Morrison a graceful way forward. "Your Honor, might I suggest that this entire proceeding has demonstrated the very essence of our legal system, the ability to examine our positions, consider constitutional principles, and adjust our course when necessary?" Rachel Anderson watched in admiration as Bronson transformed what could have been a moment of humiliation for the judge into an opportunity for judicial growth. This, she realized, was what true legal expertise looked like, not just knowing the law, but understanding how to apply it with wisdom and compassion. Judge Morrison straightened in her chair, seeming to come to a decision. "The contempt citation is hereby withdrawn," she announced. "Furthermore, I am ordering a review of all courtroom policies regarding religious expression to ensure they align with constitutional principles and court directives." The gallery erupted in quiet applause, quickly silenced by Richard Brooks's stern look, but the approval was palpable. This was how justice was supposed to work, through reasoned argument, respectful dialogue, and a willingness to correct course when necessary. Michael Cooper was already updating the court record, knowing that this proceeding would likely be cited in law school curricula and legal texts for years to come. The resolution wasn't just about a cross or a fine, it was about the proper balance between judicial authority and constitutional rights. Bronson rose slowly from his seat, the morning light catching the small gold cross that had sparked this extraordinary lesson. "Thank you, Your Honor," he said simply. "Your willingness to consider these constitutional principles speaks to the highest ideals of our judicial system." The impact of the morning's events began to ripple through the courthouse. Judges in other courtrooms were already requesting copies of the constitutional precedents Bronson had cited. Legal interns were sharing their notes through group chats. Public defenders were discussing new strategies for addressing religious freedom issues. Andrew Phillips had his headline, "Constitutional Wisdom Transforms Courtroom Confrontation into Judicial Education." But the story, he realized, wasn't just about what had happened in courtroom 4B, it was about how knowledge, respect, and wisdom could transform conflict into opportunity. Lisa Martinez approached Bronson as the crowd began to disperse. "Professor," she said hesitantly, "what made you decide to challenge the rule today? You could have simply removed the cross." Bronson's response captured the essence of his lifelong dedication to constitutional law. "My dear," he said gently, "sometimes we must stand firm not for ourselves, but for those who might come after us. Today wasn't about my cross, it was about ensuring that everyone's rights are protected, even in the smallest ways." Rachel Anderson overheard the exchange and understood its significance. Sometimes the most important legal precedents came not from landmark cases, but from small moments when someone knowledgeable enough and brave enough stood up for what was right. Officer David Sullivan, who had started the morning by confronting Bronson about his cross, now found himself thanking the elderly lawyer. "I learned more about the Constitution in 2 hours than I did in all my training," he admitted. Judge Morrison, preparing to continue with her docket, had one final observation. "Mr. Bronson," she called out as he prepared to leave, "I believe I still have your textbook in my chambers. Perhaps it's time I reviewed certain chapters." Bronson's response brought a smile to every face in the courtroom. "Your Honor, the law is a living thing. Sometimes the best lessons come not from books, but from moments like these, when we all remember why these principles matter in the first place." As the morning session drew to a close, the impact of what had transpired was still sinking in. A simple gold cross had sparked a constitutional law seminar that none of the participants would ever forget. More importantly, it had demonstrated how knowledge, respect, and wisdom could transform a potential conflict into an opportunity for growth and understanding. Michael Cooper, updating the final court record for the morning, added a personal note to his usually formal entries. "In the matter of constitutional rights and religious expression, wisdom prevailed." It wasn't standard procedure, but then again, nothing about this morning had been standard. The story of what happened in courtroom 4B would be told and retold throughout the legal community. It would become a reminder that sometimes the most powerful legal arguments come not from force or confrontation, but from deep understanding and respectful dialogue. 6 months after the memorable morning in courtroom 4B, the Los Angeles County Superior Court gathered for an unprecedented event. The chief judge had organized a special symposium on religious freedom and constitutional rights in the courthouse, and Charles Bronson was the keynote speaker. The small gold cross still hung around his neck, now a symbol of something far greater than personal faith. The main courtroom was packed with judges, lawyers, law students, and court personnel. Judge Elizabeth Morrison sat in the front row, her own copy of Bronson's textbook open on her lap, its pages now filled with notes and markers. The morning that had started as a confrontation had sparked a transformation in how the entire courthouse approached constitutional rights. Rachel Anderson, who had witnessed the original incident, was now teaching a weekly study group for young lawyers, focusing on constitutional advocacy. Her detailed notes from that morning had become a valuable teaching resource, shared among legal professionals across the city. 6 months ago, Bronson began his address, his voice carrying the same gentle authority it had that memorable morning. A simple cross became the catalyst for an important conversation about constitutional rights and judicial wisdom. Today, I want to talk about how that conversation has changed our legal community. Indeed, the changes were significant. The courthouse had established new guidelines for religious expression, carefully crafted to balance institutional needs with constitutional rights. Officer David Sullivan had helped develop a training program for security personnel, teaching them how to handle religious symbols and expression with sensitivity and respect. Lisa Martinez, no longer an intern but now a first-year associate, had turned her notes from that morning into an article for the Law Review. Constitutional Rights in Practice, a case study in judicial wisdom, had already been accepted for publication, with Bronson himself writing the foreword. Michael Cooper's court records from that day had become required reading in several law schools' constitutional law classes. His personal note about wisdom prevailing had been quoted in legal journals, capturing the essence of how constitutional principles should be applied in real-world situations. Judge Morrison had undergone perhaps the most remarkable transformation. Rather than being embarrassed by the incident, she had embraced it as a learning opportunity. She now taught a monthly seminar for new judges on balancing judicial authority with constitutional rights. What happened that morning, she told her colleagues, wasn't just about a cross or a fine. It was about remembering that our authority is meant to protect rights, not diminish them. The impact extended beyond the courthouse. Andrew Phillips's article about the incident had gone viral in legal circles, leading to discussions in courthouses across the country about how they handled religious expression and constitutional rights. Richard Brooks, the senior bailiff, had noticed a change in how the courthouse functioned. There was a new atmosphere of thoughtful consideration when issues of constitutional rights arose. It's like everyone stops to think, "What would Professor Bronson say about this?" he observed. The chief judge took the podium after Bronson's keynote address. What happened 6 months ago could have been a simple confrontation between authority and rights. Instead, thanks to Professor Bronson's wisdom and Judge Morrison's willingness to learn, it became a masterclass in constitutional law and judicial responsibility. The symposium included panel discussions on religious freedom, constitutional rights, and the role of courts in protecting individual liberties. But perhaps the most powerful moment came during the afternoon session, when a young Muslim lawyer stood to share her story. The day after Professor Bronson stood up for his right to wear a cross, she said, her voice thick with emotion, "I wore my hijab into a courtroom for the first time. When someone questioned it, the judge cited the Bronson incident and welcomed me to proceed. That's how change happens, one principle at a time, one court at a time." Lisa Martinez's Law Review article had captured the essence of what made that morning so special. It wasn't just Bronson's encyclopedic knowledge of constitutional law, but his ability to teach those principles in a way that transformed conflict into understanding. The courthouse had established what they called the Bronson Principle, the idea that constitutional challenges should be seen as opportunities for education and growth rather than confrontation. Judge Morrison had been the first to articulate it. Sometimes the best response to a constitutional challenge is to stop and learn. Rachel Anderson's study group had grown so popular that they had to move it to a larger venue. Young lawyers gathered weekly to discuss constitutional rights and how to defend them with the same quiet dignity Bronson had demonstrated. Officer David Sullivan's training program had been adopted by other courthouses in the state. "We're not just teaching security protocols," he explained. "We're teaching constitutional awareness. Every person who enters this courthouse brings their rights with them." Michael Cooper had created a special section in the court's digital archives dedicated to constitutional rights and religious expression. The records from that morning, including his personal note about wisdom prevailing, had become a frequently cited resource. Andrew Phillips's follow-up article, "The Bronson Effect: How One Morning Changed a Courthouse," had been picked up by national legal publications. It detailed how a potential confrontation had transformed into a movement for better understanding of constitutional rights. During the symposium's closing session, Bronson shared a personal reflection. "This cross," he said, touching the small gold symbol, "was my late wife's last gift to me. When I defended my right to wear it, I was also defending her memory. But what happened that morning became about something much larger. It became about defending everyone's right to bring their full selves, including their faith, into these halls of justice." Judge Morrison stood to offer her own perspective. "Professor Bronson taught us all that day that true judicial authority comes not from enforcing rules, but from understanding the principles behind them. He showed us that wisdom often speaks in a quiet voice, backed by deep knowledge and unwavering respect for constitutional rights." The symposium concluded with the announcement of a new annual lecture series on constitutional rights and judicial wisdom, named in Bronson's honor. The first topic would be religious freedom in public spaces, rights, respect, and responsibility. As the event drew to a close, Lisa Martinez approached Bronson with a copy of her Law Review article. "Professor," she said, "would you sign this? That morning changed how I understand the law." Bronson's response captured the essence of his lifelong dedication to constitutional law. "My dear, the law is always teaching us, if we're willing to learn. What happened that morning wasn't about me. It was about all of us remembering why these rights matter." And there you have it, family. Sometimes the most powerful lessons come not from confrontation, but from wisdom. Sometimes the greatest authority lies not in enforcing rules, but in understanding principles. Has anyone ever taught you about your rights in a way that changed your perspective? Share your story in the comments below. The legacy of that morning in courtroom 4B continues to grow. Each time someone stands up for their constitutional rights with knowledge and dignity, each time a judge pauses to consider the principles behind the rules, each time wisdom prevails over mere authority, the echo of Bronson's quiet victory reverberates through the halls of justice. As Bronson left the courthouse that evening, his small gold cross catching the light just as it had 6 months ago, he was followed by a new generation of legal professionals who had learned that sometimes the most important victories come not from winning arguments, but from teaching principles that would long outlive any single morning in court.